And put us live on Facebook as well. No, actually, we are not going to go live on Facebook because that's going to be a little more involved. I want to welcome you all this evening for joining us for this timely conversation with Commonwealth attorneys from across Virginia. My name is Valerie Slater, and I'm the Executive Director of Rise for Youth. And Rise stands for Reinvest in Supportive Environments. We are all about ensuring that young folks have the opportunity to reach their full potential, even when they have had justice system involvement. And sometimes that means we've got to look beyond those traditional means of crime and punishment and looking for ways to bring kids back into line and look for alternatives to the traditional ways of handling kids that find themselves in trouble. Tonight, we're going to have this great conversation with these Commonwealth attorneys, and we're going to ask some questions, but we're going to hear from them about how they are doing juvenile justice in the different jurisdictions. And then we're going to have a conversation about some guidance that we are hoping is going to begin to lead the way folks are treating children in the different jurisdictions across the Commonwealth, so that we are all ensuring that children have the ability to thrive. And so with that, I want to go ahead and turn it over to my co-host, James Dold with Human Rights for Kids.
Thank you so much, Valerie, and thank you all so very much for joining us tonight for this very important and, as Valerie mentioned, timely conversation. I'm James Dold. I'm the CEO and founder of Human Rights for Kids. We're a DC-based nonprofit organization working to advance human rights protections for children in the criminal justice system in line with international human rights norms. So as we get started here, the very first thing that I want to go through with folks is the prosecutor guidance that Valerie and I, Rights for Youth and Human Rights for Kids, developed to help inform conversations within prosecuting attorneys' offices about what to do when children end up in the criminal justice system and are accused of serious crimes. And so there's a document that we'll send out as a follow-up so that everybody has access to this. But we really wanted to create this document to help guide prosecutorial decisions around whether or not prosecutors should charge a child as an adult, and if a child is going to be charged as an adult, what crime to charge them with, and then ultimately, if they're convicted in adult criminal court, what sentence should be recommended to the court. This conversation and this guidance is really important, especially at this time, because back in 2020, the Virginia General Assembly passed House Bill 744 by Delegate Vivian Watts, which made Virginia one of the first states in the country to give judges complete discretion when sentencing youth who had been tried and convicted in adult court. So in addition to unshackling the hands of judges, it also allows judges, or requires judges rather, to consider the adverse childhood experiences that a child may have been exposed to, their involvement in the child welfare system, as well as any other mitigating factor of youth. And it really comes in the wake of the U.S. Supreme Court's recognition of how youth are different from adults and should be treated differently, and how legislatures really around the country have responded to those decisions, as well as the emerging juvenile brain and behavioral development science. And so this document is very much informed by those legal changes that have happened in Virginia in recent years, as well as the emerging jurisprudence from the Supreme Court and really around the country. And I'm going to walk through this just very quickly. A big part of this document is process focused. And what we know from the literature and from the research is that the overwhelming majority of youth who come into conflict with the law are contending what clinicians call adverse childhood experiences. Back in 1999, the adverse childhood experience study was done where doctors from California were looking at negative life and health outcomes for their patients, and they wanted to figure out if there was sort of a common denominator. And so they began to question their patients on these 10 adverse childhood experiences to determine whether or not there was a correlation or connection that existed between those poor health outcomes and what people had experienced earlier in childhood. Those studies have been replicated specifically with youth in the juvenile justice system. A few years ago, OJJDP released a report, a study that was done actually down in the state of Florida, where they surveyed all of the youth in Florida's juvenile justice system. And what they found was that roughly 50% of all of the youth in the juvenile justice system had at least 4 adverse childhood experiences. And as you can see on the screen there, adverse childhood experiences can include anything from physical and sexual and emotional abuse to living with a family member who suffers from mental health issues or substance abuse issues, having a parent who's incarcerated. And I can tell you from some of the surveys that Human Rights for Kids have done from people who are in the adult criminal justice system, as well as some of the clients that we've represented, what we tend to see is that the more severe the crime the child has committed, the higher the ACE score, the more traumatic events that they've been exposed to. This is especially true with girls in the system. More than 70% of girls that have been identified in the juvenile justice system have experienced both physical and sexual violence. There's something that our friends at Rights for Girls calls the sex abuse to prison pipeline, because sex abuse is so prevalent, especially among girls before they become system involved. And so we really wanted to make sure that, as prosecutors, as courts are figuring out how to hold children accountable for the harm that they have caused, that we are doing so in a trauma-informed way that also respects international human rights norms, particularly those that are found in the Convention on the Rights of the Child, as well as the International Covenant on Civil and Political Rights, with which the United States is a treaty party to. Both of those documents specify specific protections that are supposed to be in place for youth, particularly around not treating children by the same standards that we use for adults. And so again, ties into why this document is so important. And from a process standpoint, again, making sure that age mitigating factors are considered at the time that those important decisions are being made about a youth. And then there's a couple of the other points that I just want to highlight here. We're not going to have time to go in depth through this entire document because we really want to get to our main event. But the main thing that we want to highlight here is making the decision not to charge children who are under the age of 16 as adults. And when children who are 16 or 17 years of age have to be tried as adults because of public safety considerations, making sure that those youth can have what is known as a serious offender, youthful offender designation, which is something that Virginia has to basically give children who've committed very serious crimes the opportunity to stay in the juvenile system, get treatment and services, have their sentences reviewed. It's a bit of a blended sentencing model, but gives judges the ability to take a look at that youth every couple of years to see if they've made sufficient progress, to see if they've been rehabilitated, and to determine whether or not they are no longer a danger to public safety. And so what we really want to do is have a system that protects human rights for youth by making sure that they have as many opportunities to be reviewed, have access to treatment and services, aren't placed in adult correctional facilities, which is also a violation of human rights norms, and otherwise have every opportunity to demonstrate that they can change, that they can be rehabilitated, and don't need decades in prison to show that they are more than the worst thing that they ever did. And so with that, I'm going to stop sharing my screen. And at this time, it's my distinct honor to introduce our guest speaker, somebody who is a good friend of mine I've known for many years. And I'm going to read his bio. It's very impressive. And we're just so excited that he's here with us this evening. Doug Overby, in 2017, was appointed by President Trump to be the U.S. Attorney for the Eastern District of Tennessee. In that capacity, he was responsible for investigation and prosecution of all violations of federal law, civil defense of matters in which the U.S. was a defendant, and affirmative civil enforcement actions brought in the name of the U.S. government. In addition, as part of his duties as the U.S. Attorney, Mr. Overby served as co-chairman of the Tennessee Dangerous Drug Task Force and chairman of the executive board of the Appalachian High Intensity Drug Trafficking Area. Prior to his appointment, Doug served in the Tennessee legislature. He served 8 years in the Tennessee House of Representatives before being elevated, and was in his third term in the Tennessee Senate prior to his elevation as U.S. Attorney. He has served on the Finance and Health Committees in the Senate, chairman of the Senate Ethics Committee, and the General Assembly's Arts Caucus, and vice chairman of the Senate Finance and Judiciary Committees. Today, he practices law at Owens Wilson and Coleman, a firm he co-founded. And his primary practice areas are white-collar defense and other government investigations and enforcement, including antitrust, anti-corruption, fraud, money laundering, high-stakes litigation, particularly involving complex commercial claims and civil antitrust. I could go on and on. He has a very, very impressive resume. The last thing I want to mention about Doug that we're very excited about is earlier this year, he joined our board of directors, where he serves as one of 11 current or former state lawmakers who helped to inform our work and really forge bipartisan solutions for how to hold youth accountable when they come into conflict with the law. Ladies and gentlemen, please join me in giving a large round of applause and welcome to Doug Overby. Doug, the floor is yours.
Thank you very much, James, and thank you for your kind words and kind remarks. It is a real honor and privilege for me to be present with you this evening and be a part of this important webinar. I certainly, in many respects, don't feel worthy to be your guest speaker, your keynote speaker. I was a prosecutor for 3 years and 3 months, and I know many of the people that are on this the Zoom call have been prosecutors many, many more years and have spent their careers in the pursuit of justice on behalf of the citizens of the Commonwealth of Virginia. So I feel very privileged to be here. And I feel very privileged also, James, to be a part of human rights for kids. I believe in the mission of the organization totally, and nice to meet Valerie with Rise for Youth. So thank you for what you do, Valerie. I was probably what you would call during my time in the Tennessee General Assembly a law and order legislator. I'm sure I did my share of enhancing penalties for crimes and moving them from E felonies to D, C, B, and A felonies. But also during my time in the legislature, I was invited by a professor at Lipscomb University in Nashville to attend a class he was teaching at the Tennessee Prison for Women. At that time, I met women who were incarcerated for crimes they had committed as children. And one of those individuals was a young woman by the name of Centoya Brown. And many of you may have heard of her story. If you haven't, I'm going to go into it briefly because it's really a part of why I got involved in these issues. I was previously familiar with Centoya's story, but we had not previously met. At that time, Centoya was serving basically a life sentence where she would serve a minimum of 51 years before being eligible to be released on parole. With a sentence this severe, it was not clear whether she would leave prison alive, and if she did, she would be an old woman well into her retirement years. Centoya was born at Fort Campbell, Kentucky on January 29, 1988. Her father was unknown. Her biological mother drank alcohol during her pregnancy. Following Centoya's birth, her mother began using crack cocaine, and unable to care for her daughter, the mother put Centoya up for adoption. Growing up, Centoya spent time in Tennessee's Department of Children's Services committing crimes against persons and property. She spent 2 years at Woodland Hills Youth Development Center in Nashville. She fled those facilities and eventually ended up as a runaway on the streets of Nashville, where she met a thug whose street name was Cutthroat. During this time, she lived at a hotel in Nashville, supported Cutthroat and herself by involuntary prostitution. Cutthroat used violence to force Centoya into prostitution, and she was thereby a victim of minor sex trafficking. What makes Centoya's case particularly tragic is that she was a victim of sex trafficking. On that fateful night, She had been picked up by a victim, in her case, at a fast food restaurant. She believed the victim in her case had picked her up that night for sex and intended to harm her as she slept. She killed him first. Without due consideration for her age, trauma history, or victim status, Centoya, at the time 16 years old, was sentenced as if she were an adult with no history of mitigating factors against a lifetime of imprisonment. The truth is, the system failed her, as did the adults in her life who were supposed to protect her. While in prison, Cynthia passed her GED exam. She received an associate's degree from Lipscomb University. After meeting Centoya and talking with her, I was convinced that continued incarceration was no longer necessary and would actually, for her, be counterproductive. Following that, I introduced legislation to give juveniles like her, who had been convicted to basically life in prison without parole, an opportunity for parole. Eventually, thankfully, her sentence was commuted by Governor Bill Haslam a few years ago, and she is now free. But the sad reality is there are too many children in our system who have stories just like Centoya Brown's. All of that leads me to say this. As James mentioned a while ago, a report from the Office of Juvenile Justice and Delinquency Prevention found that over 92% of youth in detention centers have lived through a traumatic event, with over half reporting exposure to 6 or more traumatic events. The most common event, trauma, was witnessing violence. The report concluded that the vast majority of children involved in the juvenile justice system had survived exposure to violence and are living with the trauma of that experience. For children who end up in the adult criminal justice system, we typically see similar, if not higher, rates of childhood trauma or exposure to adverse childhood experiences. These traumas include numerous forms of abuse, witnessing domestic violence or substance abuse, experience poverty or violence in the child's community. Without doubt, this trauma has significant impact on a child's psychological and emotional development. Also, during my time as a state legislator, I learned that in our state, almost all the children in state custody were there because of exposure to illegal drug usage, either by them or their parents or other adults in their lives. I strongly suspect those same statistics would apply to the Commonwealth as well. So, given all of that, we as prosecutors cannot lose sight of the fact of childhood trauma, nor can we lose sight of the fact that no matter what they've done, at the end of the day, children are still children. Why do I say that? Because developmental research tells us that children's brains are less developed and they are more impulsive and less likely to be able to remove themselves from unsafe, crime-producing settings. They are also more vulnerable to negative and peer influence, making them less likely to think through the long-term consequences of their actions. The U.S. Supreme Court has found that it is these developmental differences that make children less capable for their actions, less culpable for their actions, and more amenable to rehabilitation than adults. This research has helped the Supreme Court conclude in a series of cases stretching back to 2005 that children are in fact different under the Constitution and must be afforded additional protections. Whether it's in the context of punishment under the 8th Amendment or Miranda warnings under the 5th Amendment, issues involving children require a different level of constitutional scrutiny. These differences have also helped shape the emergence of human rights protections for children in conflict with the law. In 1989, the United Nations ratified the Convention on the Rights of the Child, which prohibits the use of the death penalty and life without parole sentences for youth. It also prohibits the use of solitary confinement on children, the placement of children in adult prisons, and sentencing youth by the same standards used by adults. Today, almost every nation in the world has signed and ratified this treaty. So, what is the role of the prosecutor in safeguarding children's rights? Prosecutors can and must play an important role in upholding the constitutional and human rights of children who come into the criminal justice system. Our primary duty is really not convictions, but justice. From the decision on whether to certify a child as an adult, to what crimes to charge, and what punishment to recommend to a court. These prosecutorial decisions will have a long-lasting impact on the life of the child defendant. Human Rights for Kids and Rise for Youth have created, as James and Valerie mentioned, a prosecutor guideline document to aid you with navigating some of these difficult decisions. The big takeaway of this document is that prosecutors should consider all age-related mitigating evidence at every phase of the prosecution and continue in a way that properly balances the best interest of the child with public safety. This should include an in-depth look at the impact of prior childhood trauma and the role it may have played in a child's crime. I'll be the first to admit that it's not always an easy task, but it is one that is necessary. And prosecutors, just like all people, make mistakes. But that shouldn't stop us from trying to do the right thing so that the Centoya Browns of the world are met with understanding, compassion, and age-appropriate accountability, not a lifetime of imprisonment. I'm looking forward to the conversation this evening and finding ways to, as we work together in a bipartisan way, to advance justice in our great country. Thank you for what you do each and every day in the cause of justice and for allowing me this opportunity to join you in this critical endeavor. Thank you very much, James. Thanks for the opportunity. And I really appreciate the prosecutors who have joined us for this webinar and for what you do every day. I'm going to hang around for a while, but then I've got to get on to another appointment. Thank you.
Thank you so much, Doug, for sharing those powerful words, those truly guiding words, the words that should indeed guide our conversation. And now I have the distinct pleasure of introducing this distinguished panel. And I'm going to begin with Ramin Fatahi. He is the Commonwealth's attorney from the city of Norfolk. Ramin's office of 40 lawyers and 45 support staff are responsible for prosecuting felony and selected misdemeanor cases in Norfolk's courts. Ramin is a progressive prosecutor. He took office in January of 2022 on a platform of public safety, equity, and criminal justice reform. Ramin has prosecuted for 16 years, both in his current office in the United States Attorney's Office in Charlottesville, Virginia, and in the Commonwealth's Attorney's Office for the City of Chesapeake. Prior to being a prosecutor, Ramin worked as an assistant public defender in Richmond, Virginia, an associate at Kirkland and Ellis LLP in Washington, D.C., and as a law clerk to Virginia Supreme Court Justice Elizabeth B. Lacey. Ramin earned his BA in history from Yale and his law degree from Columbia. Ramin lives in Norfolk with his wife, Mary Beth, a master lecturer at Old Dominion University, and his sons, Thomas, who is 6, and James, who is 5. Welcome, Ramin. Next, we have Allison Linscott. And Allison started with the Richmond's Commonwealth Attorney's Office in 2016. And that entire time has been spent in the Juvenile and Domestic Relations Division of the office. In March of this year, Allison became the Deputy Commonwealth's Attorney for the Richmond Commonwealth's Attorney's Juvenile and Domestic Relations Division. Prior to law school, Allison was employed as a foster care worker at a local Department of Social Services. Welcome, Allison. Next, we have Joe Platania. He graduated from Washington and Lee School of Law in 1998 and started his legal career at the Virginia Resource Center, where he represented Virginia inmates that had been sentenced to death. Joe came to Charlottesville in 1999 as one of the original attorneys at the then newly opened Charlottesville Albemarle Public Defender's Office. Platania joined the Charlottesville Commonwealth Attorney's Office in 2003 and was elected Commonwealth Attorney in 2017. He was a cross-designated Special Assistant U.S. Attorney for the Western District of Virginia from 2008 to 2017. In addition to his duties as Commonwealth Attorney, Platania currently serves on the Board of Governors of the Virginia State Bar's Criminal Law Section, the Board of the Charlottesville Albemarle Drug Treatment Court, and the Charlottesville Albemarle Restorative Justice Advisory Committee. He is a member of the Virginia State Bar's Disciplinary Board and previously served on the 7th District Disciplinary Committee. He is the director of the Prosecution Clinic at the University of Virginia School of Law, and is also a member of the Virginia Criminal Justice Conference, an organization that seeks to improve criminal justice in Virginia. Welcome, Joseph. And last but absolutely not least, we have the native of Charlottesville, Virginia, Shannon Taylor. Shannon is a 1989 graduate of the University of Virginia. Her first job after college was a paralegal at the Richmond-based firm of Hunton Williams, now Hunton Andrews and Kurth, which inspired her to pursue a career in law. Shannon received her law degree in '95 from the University of Richmond School of Law, and she began her career as a prosecutor in the Commonwealth Attorney's Office for the city of Richmond. Based on her competent and successful prosecutions, she was named as a special assistant in the U.S. Attorney's Office first in 1999, and then again from 2002 to 2004. Shannon was special counsel for the Richmond Multi-Jurisdictional Grand Jury from 2004 to 2008. The special counsel's job provided an opportunity to gain valuable experience working with Virginia State Police, the Alcohol Beverage Control Board, and the Virginia Department of Taxation. After 3 years in private practice, Shannon was elected Commonwealth Attorney for Henrico County in 2011, the first female to hold that position in the county's history. She was reelected in 2015 and again in 2019, this time carrying every magisterial district in the county. As Commonwealth's attorney, Shannon prioritizes compassionate, effective, progressive policies to move Henrico forward as the best way to keep the community safe while stressing rehabilitation. Shannon fully recognizes the importance of civic involvement to public safety and works closely with neighborhood and community associations. Welcome, Shannon. Again, what a distinguished panel we have. I'm very excited for this conversation. And yeah, I'm going to pass it to you, James, to ask the first question.
Absolutely. Well, thank you, Valerie. And again, thank you to our esteemed panelists. The first question we have is, can you all share more about how your office handles cases involving children accused of committing crimes? Please specify any internal processes you have in place as it relates to the charge in either juvenile or adult court. Our audience is kind of broad here, so there's some folks who may know some of those processes, but there are others who may not. So please feel free to add as much specificity as possible. And we'll go ahead and start with the Madam President of the Virginia Commonwealth Attorneys Association. Shannon, we'll kick it over to you.
Thank you also, James. Thank you, Valerie. Of course, thank you. And Mr. Everby, thank you for sharing with us your experiences. As you've been around for a long time, and I mean, so have I. I've been doing this for over 25 years. And let me just start off with that, I don't get into the nitty gritty of my bio, but when I started off my career in the city of Richmond, I started off in juvenile court. And I often talk about, when I've been speaking in public, about kind of my journey of where I came, which is the old adage of, if I knew then what I know now, I would totally have done things differently in juvenile court. But also to have an understanding of the level of my naivete coming from, I went to from outside of Charlottesville, which is Albemarle County, went to public school there, and really had no exposure to to socioeconomic challenges. So when I come to the city of Richmond, which was based in our history of having a lot of housing authorities and a lot of courts, and understanding that, here are children that are living in settings that I do want to recognize there are families that were very proud of where they have come from. But there are also a lot of families that were dealing with a lot of issues, and to understand that the dynamics of a family and the impact that those dynamics had on a child, or even just what they were observing just in day to day. For example, to actually witness a homicide. That's still happening today. And, to see the violence that is occurring wherever these children are at the time that the violence is happening, and having an appreciation. One of the things that I have kind of carried over into this office as a leader is an understanding of what happens in a young person's, past is what is going to directly impact them today. We say this all the time, just as I just said, my own life experiences had a particular impact on me. How could I not expect someone else who's coming through our court system and their life experiences not to have an impact on them? And so a lot of times, what we're trying to understand is when the children do come into our juvenile system in Henrico County, we have a very robust court service unit. We do a lot of diversion, and let's also be mindful that our court service unit directors are employees of our state Department of Juvenile Justice, which of course is an agency under the governor ultimately. And through administration to administration, there can be different emphases, even though we all know fundamentally for juvenile courts, the number one aspect is rehabilitation. So in working with our court service unit directors and understanding the leeway that they have been given and the discretion that they're given, we do try very hard to work with the young people in diversionary practice, meaning for those who don't have an intimate knowledge of the court system, meaning that the young person never comes before, the person in the black robe. They never come before the judge. They're given an opportunity to engage in counseling. That can be family counseling, going through other type of programs to give them an opportunity to demonstrate, responsibility. But I think another part of this that I have taken on, as a personal choice, is my engagement with understanding what schools are doing, because a lot of these kids, schools, first of all, that's an environment they're in more than they are at home, more, for a majority part of the year. And I really want to understand, and have been fortunate enough to have that type of relationship in Henrico County Public School System, to understand that they also need certain resources to address the behavioral issues that are happening in schools. So, by the time a child is coming to Henrico courts and are actually appearing before a judge, there's a lot of things that have happened, and maybe they haven't worked the right way, but the matter is just so serious that the code dictates that they have to come before the court. And in any event, we are constantly trying to understand the behavior aspect and the mechanics of what's going on in a child, and the idea of ACEs, or I think we've got a different tool that we're using in Henrico now, which is SAES or something like that, that is trauma and poly-victimization aspects. But to understand, what is going on in a child's life that has created this environment and that has impacted their decision making, that can we address that? I will say I've already taken a sneak peek at I think it's Miss Champion, who has written two questions in the chat room, and she's pointed out a couple other things, developmental disabilities, how important, and autism, the idea that we expect schools to understand these things because children do come with IEPs and 504s and behavioral plans. We need to make sure that we are equally well-versed in those concepts and what it means. In Virginia, we just passed a law a couple sessions ago that says now you can take in consideration the IEP and the behavioral plan when you're determining whether or not there's actually intent to have committed a crime. And so, not to get into the weeds, but there we're also trying to work with schools about allowing us to have that type of documentation so we can make the best thing going forward. So James, I'm to your point, and understanding what Mr. Overby is saying about the human rights aspect of it, it is still a very delicate balancing act, because we are trying to understand that there is a level of responsibility of one's actions, and trying to understand what does that mean to hold somebody accountable for their actions and the harm that they may have done to somebody else, but also understanding that the response to that young person to, again, respect that rehabilitation is the number one focus. What can we do in the best way fashion that recognizes that level of responsibility and acceptance of their actions, but also making sure that we are giving the right response to these young people to make sure that they have the tools to make better decisions in the future.
Wonderful. Thank you so much, Shannon, for that response. And I would like to give opportunity for any of you others that would like to respond to that question before I move on to the next one.
I can say in Richmond, we have specific written guidelines for when we seek transfer for juveniles or when we seek certification for juveniles from our elected Colette McEachin. Our written policy indicates that we will not seek transfer of any juvenile for a non-violent felony. The only person that can make the decision to deviate from that policy would be Colette McEachin after a conversation with the Deputy Commonwealth Attorney and the assistant that believes it might be necessary for that case. Also, for 16 and 17-year-olds charged with violent offenses, we enumerate specifically what violent offenses. We ask for the report to be prepared pursuant to a new statute by court service unit that helps us inform, helps us learn more about the juvenile, because at the beginning, we don't know that juvenile's history. So it's important to get as much information and information gathering as we can to make the appropriate decision as to what might be necessary. Once the assistant Commonwealth Attorney requests that report, if they still think that certification might be appropriate, they have to discuss it with the Deputy Commonwealth Attorney before a final decision is made to certify that juvenile up to circuit court. Additionally, we have a presumption written that juveniles charged with violent crimes age 14 to 15 should not go up to circuit court. That is our presumption. If a assistant Commonwealth Attorney feels differently for some reason, they must have an in-depth discussion with the deputy before a decision is made on that. So those are policies that have been placed under Colette McEachin for a significant period of time. Those are given to our new attorneys in JDR when they come in. And there's a discussion about that and what these conversations should look like. So that is something that we have implemented and I think has been working really well to consider a full picture when looking at a juvenile and taking into consideration what they might have experienced in their life.
You go ahead.
I think you were still on mute, so I was just letting you know.
So I guess I will go ahead then with our next question. And so over the last 20 years, we'll move on to that next question. I just want to highlight some of the things that were said. So Shannon, I just really appreciate your taking a look even at Ms. Champion's questions and recognizing that we do have to take into consideration the developmental challenges that any young person may potentially have. Allison, thank you so much for laying out succinctly exactly how y'all make these decisions in the Richmond office. And Shannon, how robust the process is before a child finds themselves even before the court, right? That matters. It matters that you are taking the time to offer all of these alternatives before potentially a young person might find themselves before the court. And then even when they do, that you're still recognizing we're still talking about children. We have still got to recognize that the number one priority is rehabilitation. I just wanted to lift up those key points. And now, over the last 20 years, the Supreme Court has come down with a series of rulings that have really reinforced this principle that children are constitutionally different. And we've got Roper v. Simmons, the death penalty, no longer an option for children. Graham, Miller, Montgomery, and Jones that basically eradicated the juvenile life without parole. And then JDB versus North Carolina, and just really lifting up that kids have Miranda rights as well. So first of all, what's your view on the court's jurisprudence in these areas? And then secondly, what, if any, policies do you have in your office that safeguard the rights and the constitutional protections for young people? And Ramin, can we start with you?
Sure, I'd be glad to. I'd be glad to pick that up. Nice to see all of my friends on board. Allison, we're going to have to get you to federal court. You're the only one who hasn't been a federal prosecutor. So talk to Colette about that. But I started out my juvenile career anchored in the Oliver Hill Courts building, courtroom number 4, in front of Judge Kimberly O'Donnell. So the Supreme Court has clued into what I consider to be the major advance in our understanding of the importance of treating juveniles differently. When I started prosecuting, which was started working as a criminal lawyer in the mid-2000s, there was really no appreciation that there's an intermediate stage of human development in between childhood and adulthood. You know, we kind of call it adolescence, we call it young adulthood, but we have now learned that the prefrontal cortex, the part of the brain that controls our ability to control our impulses, does not come online until we are in our mid-20s, roughly 25. And that means that when we are looking not just at children, legally children, you know, people 17 years and 364 days and below, but also young adults, that we have to consider that they are not operating in the same way that a 30 or a 35-year-old is, and that they can seem 50 at one moment and 5 the next. And that we really have to be careful and not judge a 17-year-old or a 16-year-old by the standard we would use for a 30-year-old. The United States Supreme Court has historically used social science data and scientific sort of knowledge to inform its decisions. I'm afraid we may see less of that in the future with the current composition of the court, but they integrated those ideas into their jurisprudence, and they've recognized that it is cruel and unusual to treat a child the way you would treat a 50-year-old. So that's both normatively appropriate and it's scientifically consistent. As far as the policies that I have in place in my office, a lot of them have to do with making sure in the ways that Colette has done in Richmond, and I know that Shannon and Joe do in Henrico and in Charlottesville, that just like we don't treat young adults like they're 50, we don't treat young prosecutors like they're the 3 of us, the 4 of us on this call. I have a written policy in my office, and I took a page out of the Justice Department's playbook. It's public, it's available on my website, that lays out rules of the road for my prosecutors and also indicates where they need to go up the chain. And when it comes to juveniles, my policy that I put in place in my office is that we send juveniles to adult court only where they have exhausted every other option available to them in the juvenile system, and that they are a threat to public safety. And the only person who can file a notice to transfer or to certify a child, which are the ways to take a child to circuit court, are my one juvenile court deputy, and my juvenile court deputy has to speak to me about it as soon as it's practicable. Statistics in criminal law are hard to come by and are easily manipulated, but I can tell you that, in the 4 years prior to my taking office in January, we averaged just about 17 and a little bit children going up to circuit court a year. This year, it's 6. And and those 6 are possession of a machine gun, shootings, robbery, carjacking, murder, malicious wounding. We were talking about really the crimes of serious violence, and with children who are not 14. So by creating those guardrails and also reminding, and I reinforce this with my prosecutors, remember 25, it's not 18 in a day, it's really 25. And sort of instilling that mindset in my young prosecutors, but not allowing them to make the call, sending it to somebody with more experience, is a way that I've worked to try and respect the rights of juveniles and our evolving understanding of what to do with them. I'd also say, juvenile life without parole, we're fortunate that the Virginia Supreme Court has also recognized that this is unconstitutional and they want to do something about it. But as a general matter in my office, one of the other guardrails that I have put into place, not just for juveniles and young adults, but for all people coming through the system, is that death by life is not something that the average prosecutor can choose. There are upper bounds that my prosecutors, if they are seeking a sentence in excess of certain thresholds, depending on whether it's a nonviolent crime, there's one threshold. If it's a violent crime, it's another threshold. They need to seek my approval personally. My 40 prosecutors, they have to meet with me personally, and they have to explain to me why they think that that sentence is justified. And then I have to sign off on it so that I own it. And I don't find out that a 4 or 5 year prosecutor just got a 50-year, 70-year life sentence on somebody who didn't deserve it, regardless of whether they're 16, 17, or 37. And that is, in some offices, that's considered to be clipping the wings of younger prosecutors, but we're dealing with people's lives here. And we're dealing with a state that has no second look legislation. There's no way to change adults' life without parole sentences in Virginia unless you're the governor. And so instead of trying to fix the problem on the back end, it's very important for all of us as elected prosecutors and for Allison as a supervisor of line prosecutors to make sure the inappropriate hammer doesn't drop and then it can't be taken back off again.
That's great. Thank you so much. And Joe, did you have anything else you wanted to add to that?
Yeah, just a few thoughts. First of all, I'd like to point out we have a circuit court judge recently retired, Judge Moore, and he always tells the lawyers appearing in front of him, words matter. And he says the words you use matter and choose them carefully. And I just want to point out in the questions that we're going over that you're using the word children charged with crimes. You're not saying defendants or juvenile offenders. You're using the word children, and I appreciate that and wanted to point that out because we're talking about children, and words matter. And I noticed that, and I think we should be mindful of that. The question deals with policies, and I have a sign up in my office that says culture eats strategy for breakfast. And what that means to me is, it's from a business book. I think it was Peter Drucker, and maybe I'm too lazy to write policies, but what I try and tell the people here, and we're a much smaller shop than Shannon and Richmond and Ramin and Norfolk. We're 6 attorneys. But what I try and tell everyone that works here is, look, if our culture is in every case and in every instance and in every decision we make, we have a culture of balancing community safety with the fair treatment of someone charged with the crime. Like if that's our guiding culture, we're going to get it right most of the time. And fair and just prosecution run by Miriam Krinsky out of DC put forward 21 principles for the 21st century prosecutor. And one of those 21 principles is treat kids like kids. And that's literally what the principle says, treat kids like kids. And, I'm big on simplifying and not overcomplicating, but I think that's something that, we can use kind of as our North Stars. Are we treating children like children? not to excuse some of the choices they've made oftentimes when we're dealing with them in the criminal context. And then, we had a case where an officer responded to a shooting and a child was running away from the shooting and matched the description, and the officer tackled the child, and he Mirandized him and started asking him questions. And it was a brand new officer. And Allison, you probably can comment on this being a juvenile specialist, but I think 16.1 in the code says, you're required to give parental notification before you question a child. And this officer wasn't being malicious or ignoring the law or trying to do anything underhanded. He just didn't know. And so, of course, there's a full confession to the shooting as the officer is sitting on the kid on the sidewalk asking him questions. And so we use that as an opportunity to sort of bring the officer in and teach him and educate him and explain, look, when you're dealing with kids and children, they're different, and there's different rules, and there's different things you've got to think about and consider. And so, I think thinking things through of, opportunities versus, letting it go or not addressing it. And then lastly, I think as prosecutors, we sometimes miss, well, they did something wrong, let's just convict them and document it and punish. But I think when we think that way, what we miss is, and I'm guilty of this too, but I think if we take a more nuanced, sophisticated approach to say, what intervention and diversion will allow us to not have them come back when they're 18 into the adult system? Like, what can we do? I think I wrote it down, Valerie, you talked about children having the ability to thrive in your opening comments. What decisions can we make, and what can we do while protecting the community and keeping everyone safe? What can we do to rehabilitate and to divert and to provide services and support so that they can thrive and not come back into the system as they get older? And everyone wins when we do that. Everybody, not only the child and their family and their support system, but the whole community wins. And my last point before I hit mute is, I think Mr. Overby said it, is, our job as prosecutors is not to convict people. It's really not. And sometimes people are like, what? Our job is not to convict people. It is to do justice. And there's a comment to the rule of professional conduct dealing especially with prosecutors that charges us with being ministers of justice. And I've said before, I don't know what the definition of a minister of justice is. I don't, they can't point you anywhere that tells you what that is. But again, if that's another concept, and I know my colleagues and Shannon and Ramin and Allison, I don't know you, but Ms. McEachin, certainly, you've got prosecutors on this call that really, I think, try and think through and be mindful of, not that we always get it right, but what can we do to be more of a minister of justice than, just trying to run people through the system and convict them. So I've really appreciated everyone's comments and listening, but those are just some general thoughts I have on what we've been talking about so far.
Great, thank you, Joe. And it was a great setup and segue into the next question, actually. And before we move there, I have to give another shout out real quick to Delegate Vivian Watts, who was also the bill patron for House Bill 746 in 2020 that created the requirement for children's parents to be notified when they're arrested, and for the child to have an opportunity to consult with their parent before they can waive Miranda. And speaking of which, that's an issue actually that other state Supreme Courts around the country have sort of grappled with as well. In North Dakota, Vermont, years ago came up with the interested child standard, or interested adult standard, rather, whereby if a child did not have the opportunity to consult with an interested adult prior to waiving Miranda, any statement that they made was deemed inadmissible in court. And of course, that same protection hasn't been made applicable federally through the federal Constitution, but it's an example of other constitutional rights that are afforded to children in other states. And the next question really is sort of at the heart of that, which is, are there other constitutional protections under the 4th, 5th, 6th, or 8th Amendments, or other constitutional provisions in Virginia that should afford greater protection overall to children in criminal proceedings than adult defendants? And I'll throw that out there to the group. I know it's more of a little bit of a philosophical question for you all, but since you have so much experience in the criminal justice system. Just wondering, in your experience working on both the criminal, on the adult and the juvenile side, are there greater protections that we should be affording to children constitutionally that we currently don't?
I can touch very briefly on this and then hand off. I want to give a lot of credit to Delegate Jackie Glass. Jackie put forth a bill in the last General Assembly session, one which I supported, and I want to say other people on this call did, but you all have to. I lost track, but I did so much lobbying. But it was a bill that and people jumped on different bills at different times, but it was a bill that would have prohibited the police from basically lying to children. And the bill failed. It met some resistance from the usual suspects, but it was very much predicated on the idea that setting aside the fact that, the normative, setting aside whether the police should be able to lie, when you're dealing with the suggestibility, with the increased suggestibility that children are sort of have, should that be something the police are allowed to do? And those are, I think, very valid questions that our legislators need to hammer out, and that we're not going to see it changed in individual police departments. And in Virginia, we don't have the power to force departments to do things the way other states do, which they do by basically refusing charges. We can't do that. But I think it's a discussion that we need to take back up in Richmond. And it's another example of our votes mattering, and what representatives we send and what statewide elected officials we send will have a major impact on what other protections we put in place for children.
Oh, Shannon, I think you're on mute.
Well, I was just thinking, because Joe and I just had a recent conversation that I'm not sure if it's more of a due process than anything else, but this notion of having our juveniles be held accountable for monetary penalties when they're 14 years old and they don't have a job. And the notion of how there really could be an equity argument there, that, particularly what we see with juveniles is that they say, you're not going to get your license. Your privilege to drive is going to be withheld if you don't pay these fines and costs that are associated with this other paper. And, the balancing act of holding, parents and or guardians responsible, but sometimes maybe the state is the guardian, and how does that come into play? And the idea that we might be, imposing a penalty on a group of, socioeconomically deprived youth, and who don't get that privilege because they can't pay, these fines and costs. And this is a new idea. But was certainly, it's intriguing to me whether or not there is a kind of a constitutional argument there that we're doing harm to a particular group that really shouldn't. And Joe, I don't know if you've got any thoughts on that particular issue, because I think what Ramin talked about, we had a robust conversation about that too, and I don't like it. I mean, we tell kids not to lie, so why do we lie in front of them?
Yeah, I mean, one of the, being a public defender in Charlottesville on Friday and then being a prosecutor on Monday in the same community, I sort of joke I got better looking, funnier, and smarter. Like all of a sudden, and I was the same person, and everyone's like, oh, what do you think? And my jokes were great. And I was like, what in the world happened? And, the power that prosecutors have vested in them through the exercise of discretion is just unbelievably massive. And there's this great book by, I think it's James Pfaff, it's called Locked In, but he says, the real path to reform is to have, elected prosecutors like Colette McEachin and Shannon Taylor and Ramin Fadahi, because they are in charge of their own backyards and their own criminal justice systems, and the policies and the guidance that elected prosecutors like those three provide is just really massively important. And so, Yeah, that I don't know, but this is where you need sort of prosecutors, in my opinion, to be thinking through these issues. And I did want to just quickly, if I might, Susan Cornelius said, is it possible to have a law requiring only juvenile trained prosecutors handle juvenile cases? What a great question. I just wanted to say that to be an elected prosecutor and say, I'm going to stick someone into juvenile court to learn, like that is the exact worst mindset to have. Is those are some of the most impactful, important, and Allison, you practice there, but like those are some of the most impactful cases and decisions and case plannings and diversionary opportunities you have. And I just want to stress again, it's what I said, like you have the opportunity to not see them again when they're 18 and older, and everyone wins. And, Shannon talking about not saddling a 14-year-old with court costs and the collateral consequences of that. There's so many decision points that we can intervene and think through, how to off-ramp them and get them out of this system. So that was a bit of a ramble, and I don't know if I answered your question about the court costs, but, I think that it's just, I appreciate Ms. Cornelius's question and observation.
I was just going to add that I think that Virginia does a much better job, recognizing the uniqueness of juvenile court and putting people who actually want to do that work. It's not the punishment. It's not the exile island that when I started in 1996, it was like, oh, we'll just put them there. But I think we are much smarter today. I think leaders of offices are much smarter today. And the people who are doing the cases in JDR courts across the Commonwealth are passionate about the work. And I think we're doing a good job in Virginia with that.
Thank you all for those thoughts. And Ramin, did you want to share a thought?
I always thought you were handsome, Joe.
I know you're recording this, and I'd like 3 copies of this, please.
Oh my goodness. Well, you know what? I want to lift up some of the points that y'all have made, because, we also had a Senate patron for that bill, especially that one on lying to kids. It was Senator Saravel who carried that bill to end that practice, because, you're right, Shannon, we tell children not to lie, and yet we lie to them. Right. And at the same time, telling them that they're going to be in trouble if they lie back. There's something inherently flawed in that practice. And so it's great to hear y'all saying that. And I know that on the defense side, some of the challenges or the fears were that if we remove that, but there are other issues that may have happened during an interrogation or during an arrest, other things that may still be wrong with some of the information that has been gathered. We've got to make sure that judges are aware that stopping this one practice does not preclude and foreclose the idea that there might be other things wrong. And so if we can get that kind of an understanding in your hearts and minds and in the way you all are thinking, not to say that it isn't already there, and I quite frankly, this group, I know that it already is, but just kind of putting that out there into the ether, right? So that we all recognize that that's an issue that also needs to be addressed. One other quick thing, I want to go up to the previous question that Ms. Cornelius asked, and it's about how do we get the circuit court judges to understand that when a child does have that blended sentence, when they are going before the tribunal again and again on those serious offender reviews, how do we help circuit court judges understand that review process and the leeway that they hold and wield in finding that release is appropriate? And I'm going to turn that question over to y'all. But before I do, I also want to say I agree. Prosecutors, in many respects, are the most powerful person in a courtroom. You're the one that's making the decision on what to charge. You're the one making the recommendation for what sentences are. I mean, there are so many things that you all control. And so being mindful and working as a minister of justice versus I need a conviction, right? Okay, now let's go back to the question and I'll turn it over to whoever would like to take that on.
I'll start off and I'll apologize for, I hope this doesn't sound too snarky, but it starts off by putting the right people on the bench. Because if you do not have people who have either not had some experience, and, and I'm not suggesting that everyone on circuit court has to have, criminal experience, because what I loved hearing about Allison's background was that, even though she's been a prosecutor in Richmond for, the 6 years, she has this other life experience, right? That she understands the system, she understands DSS, she's been a foster parent, and she has an appreciation. And you have to have people who have had life experiences that give them a perspective to understand that people can change, and that they can have an appreciation that while we had a young child that did something at 16, in this 5-year period, they have proven to be exceptional. And I'm proud to say that in, the 10 years that I've been the elected here, that I've actually seen probably more than not of the reviews that have come through from cases that occurred, of course, obviously before I was the elected. And I've seen judges either suspend wholly the adult sentence or significantly reduce and allow the young person to pull the additional 24 months at our local jail so that they can engage in, in work release and have that meaningful connection back with their family. But it starts with the people that we're putting in the black robes.
Yeah, and if I can jump on that, other than flattering Joe, I have something to add to that. Shannon is absolutely correct. We can argue everything that we want to argue, but the judge is the judge, and judges will listen to us sometimes and they won't in others. The people that judges do listen to are legislators, and who legislators listen to is y'all. So I'll tell you, I practiced early in my career, Mothers Against Drunk Driving, every DUI docket. If they thought a judge was deviating from what fairness required, they had somebody there taking notes, and then they would make calls to legislators. So if you hear that there is a judge who is not taking into account the current social science research, is not imposing sentences that are consistent with what basic fairness is asking for, is going over the top of what people are recommending, like, call your legislator, explain to them, because, to quote my mom, like, the legislators brought those judges into the world and they can take them out of it. Where there's no life tenure in Virginia. Judges serve in the trial level for 6 or 8 years at a time. And, Shannon is absolutely right. Like, our brand of justice is only as good as the judges who are doing it. And if you got a judge who's terrible, like, make sure your legislator knows so that they can maybe find you a better judge.
I would also just add, I think in some respects, it is generally acceptable for the line prosecutors to inform their judges when they don't know what their options are. I've had judges ask those questions, as I have recently been in court on serious offender reviews, and just letting the judge know, if you deny this 2-year review, there is another year review. These are the options that you have, and just making sure that you share that information, if you are aware of it, of what their options are for a blended sentence and what that release might look like.
Thank you for those responses. And, I am deviating just a bit, James. I'm going to turn it back over to you, but I'm going to go through our Q&A that folks have kind of written in. So our next question is from Ms. Hendricks, and she's sharing that there's an increase of mental health challenges for youth since the pandemic. We are all well aware. We are watching. Literally, we're watching what's happened once we have shut everything down, and now we've opened it all back up, and we shut it down without folks having all of the resources necessary to be successful in their own little microcosms, right? Folks who were living in economically challenged situations and other kinds of stressors, those stressors got larger, not smaller. And so now that we are watching this increase in mental health challenges for youth in particular since the pandemic, how are we going to prevent or intervene? And those interventions really need to start looking like partnering with programming. But how do y'all own a piece of that work?
Well, I'll start just briefly. We had a series of shootings involving 14 and 15-year-olds, and the police did a great job, and they identified and placed charges against them. One child was shot 7 or 8 or 9 times, and just because we're so close to a world-class trauma center at UVA Medical Center, the child survived, and he was also shooting at people. We didn't end up charging him. But I want everyone listening, and I like how Ramin was sort of communicating to whoever might be watching this or the recording. When we as prosecutors get situations that have already happened, we're somewhat limited because it's already happened. And so we had these rash of shootings involving children, and I issued a press release, which I rarely do, and I called on the community for help. I said, we need help. Faith leaders, coaches, teachers, parents, mentors, like, we need help before this happens, because once it happens and it's on Shannon's desk or Allison's desk, you know, their toolbox doesn't have a whole lot in it once someone's been shot. So I guess my first thought is, it's a great question and be aware of it, but we need sort of help on the front end before something happens. And I agree, we're really starting to sort of unpack some of the significant mental health impacts that COVID had. But and as prosecutors, we can get out there and use our voices to do outreach and get folks rallying around, helping support these kids and give them structure and stuff to do. But it is a huge problem, and I would be happy to hear if someone has a good idea how to tackle it. I basically, in my press release, said, I don't know what to do and need help.
I mean, I'm going to brag on Henrico a little bit because we have, for the last year, been convening what we call the county managers youth intervention and prevention work group. But it did stem from this time last year, so the beginning of school year, 21-22, with 6 guns being brought to Henrico County Public Schools, which had never happened before, COVID. And this idea of what then all of a sudden we saw, which is that this great, uptick of fights. I mean, fights where we have SROs and some of our in our schools, and they got bit on the arm. And it was just crazy. It was pandemonium. And then worse, like Joe was talking about, this idea of kids shooting kids and kids killing kids, and us trying to figure out, like, why is this happening? And like Joe, I stood up from a young man at the end of last school year, outstanding basketball player. And there's his team, everyone's crying. And I'm, imploring the adults there, going, help us figure this out, and by the way, government, don't tell them to come to a town hall. Like, we need to go out there and we need to go, to see them and figure out what's going on. And so having this, this monthly, it was much more than monthly, but now, because we've been going for a year, having this monthly meeting, having the superintendent, the police chief, the director of mental health, my office, all the people within the superintendent, the school system administration, the county manager's office. And we're all talking about things. We're all saying, okay, what changes have we made? Did this work? If an incident happened, what can we do better? Revisiting policies, right? Because you have one situation of a kid bringing a gun to school, but he's 18, and we're handling that in general district court, and they're looking at that differently than the kid who comes through JDR. And oh, by the way, DJJ has changed their policy saying any child with a gun now needs to be detained. But my kid who was 18 in school was on, got a bond. Like, what's going on there? So we're trying to figure out, like, exactly how we try to handle responses, because unfortunately the other part, which has been part of this material, Valerie, that you shared, is this notion that we can come up with policies, but you are always going to have that round peg child that you're trying to jam into your triangle policy hole, and it's just not going to fit. And if you keep trying to do that the same way, that child is not going to be able to get the necessary response that they need. So, we're, and here's another, word that we like to use around in law enforcement, fluid. Like the idea of policies that we do, that we believe that we're acting under the best practices that we know, then all of a sudden kind of hit this point where, wait a second, now we've got some additional information, or, oh, by the way, now we have, this uptick in juvenile gun violence. And now my community's like, what's going on? And now we're trying to move a little differently to say, okay, public safety is, what the community's talking about. But again, that delicate balancing act of why are these kids bringing the guns to schools? What's happening in the home? Do I have a mom that I've heard say, I'm terrified of my child? I cannot tell, the police that I know that he's got 3 weapons in the home because I'm terrified of what my child's going to do. And it goes back again, we've been saying this and we preach it all the time. If we could do all of the stuff that we want to do in the very, very beginning of a process, God, we would be able to, I believe, solve so many of the problems that we're now trying to respond to. Because like Joe said, we're being very, very reactionary, not proactive. And then, to Ms. Hendricks, question about the mental health, which I am very passionate about. We are in a Commonwealth of Virginia that is woefully lacking in the appropriate resources. The one hospital that was to be dealing with our children who were desperately in need had we went from, it was a 100-bed facility, but because of COVID and because of staffing, they were down to 11 beds. And you're thinking, what is happening to all these children who don't have access because they have really deep-rooted problems? Or, what are we doing with our foster care system, our placement of children who are having real struggles because they're in a family dynamic that is not in their best interest? What about that system? And what are we trying to do to address all the multifaceted aspects where children's lives could be touched? Whether it's more family advocacy in our schools, where it's having more and facilities for children to go, like Virginia Treatment Center for Children or the Children's Hospital here in Richmond. But just where are all these resources? Because we have got, and I'm on a little bit of a soapbox here, we have got a generation right now that we have no idea what COVID has done to them. Because literally, I tell people this all the time, you didn't have to get COVID to be impacted by COVID. Every single adult, we were all changed. We were all isolated. That affected every single human being in this nation and in this Commonwealth. And until, to Ramin's point about putting people in the places of power that have, direct oversight of the money, of how this is being spent, putting people in particular executive offices who are mindful of the desperate needs that impact a majority of the citizens in this state matters. And, and so it's about, again, everyone on this call who has a voice in the Commonwealth of Virginia to speak up about how we need the resources to help these kids. And then I'll stop.
Valerie, if you don't mind, I just got to throw love to Kezia for the work that she's doing with Young Investors Group here in Norfolk. Kezia, there are no easy answers. We have it a little better than other places. Children's Hospital, the King's Daughters, just opened their juvenile psychiatric facility. So we'll have some more resources. New Virginia Majority is helping, by walking children from bus stops to their homes in some of our rougher public housing projects. But, this goes back to ideas that you don't hear people talking about as much now, but that didn't go away. Structural racism is still here. The criminalization of poverty and childhood are still here. Implicit bias is still here. And people are still going to pay for prisons before they pay for hospitals. And we've been very fortunate. We had a 2-year stretch where those ideas were in retreat, but with the COVID provoked increase in violence, which is exactly what you're talking about. It's a direct manifestation of mental illness and mental pressure on children and adults both. We've seen some of this talk retreat. And the get tough, knock heads, lock everybody up crew is back in with the upper hand of the conversation. But the problems are so far upstream from us, and the solutions are so far upstream. I put a link in the chat window for an article that I just read yesterday, and it's about psychiatrists working out of Morehouse Medical School, and about the fact that Black children are diagnosed and misdiagnosed consistently with defiance disorders and aggression and other sort of psychiatric problems that are really the manifestations of anxiety and depression, and that there's a huge racial divide. The white kids get diagnosed with the anxiety and the depression, and the African American kids get diagnosed with the defiance disorder. So this is a multi-generational project, and Shannon and Allison and Joe and we're at the end of the line picking up the pieces when the childhood trauma, all of the things that rise for youth, that Valerie and James are talking about, and that your organization has talked about in your guideposts for prosecutors. All of those adverse childhood impacts, we get the child by the time that manifests itself in criminal behavior and oftentimes in violence. But it is, we can partner as much as we can, but it's almost always by the time the child is criminal justice system involved. It's very difficult for us to touch upstream other than through advocacy, being present in the community, doing the things that the four of us prosecutors on the call have done. But there's a much bigger problem here than just prosecutors and crime and punishment. It's a basic lack of investment in minority communities and in poor communities, a basic lack of investment in medical research having to do with women and minorities. You caught me late in the evening, so I could rant about the fact that most pharmaceutical studies are geared basically towards men and towards white men, and therefore, it's more difficult to tell whether drugs are efficacious for women or for people of color. Because the studies don't tend to have a sample size large enough from those groups to be able to give us reliable data. So this is we need people like you, Kezia, in the community, to try and work. We need, we can advocate, but this is a monster, 10 megaton problem that is way bigger than us.
And Ramin, thank you for that. And that's a great segue into the next question that we have. But before I get there, I also want to highlight, this campaign that Rise for Youth and Human Rights for Kids have launched around redefining the vital signs is all about creating a public health response. And creating healthy communities, right? And Dr. Nadine Burke, I don't know if folks are familiar with Dr. Burke, but her research, she's the Surgeon General of California right now, and so much of her work has been around centering adverse childhood experiences around increasing public health responses across the board, right? And so I know we talk a lot about ACEs in the context of kids who come into the justice system, but ACEs really are the undercurrent of so many of our broader social ills, right? Whether we're talking about increased likelihood of alcoholism, drug addiction. I had a cousin who died tragically in my second year in law school of a drug overdose. Based on his ACE score, he was already predisposed to having a 5,600% increased likelihood of dying of a drug overdose, right? So all of these things we know intuitively from the data and the research around childhood trauma, and it's just more exponential once youth end up in the justice system, because at that point, the trauma has metastasized to the point where, it's the old adage, hurt people hurt people. right? And it's the same is true with our children, right? Kids join gangs because they're trying to escape the hell that they're running away from in their homes. They're looking for protection, camaraderie, all of those sorts of things. And so, to your point, I think what everyone's raised, Shannon, Joe, Allison, and Ramin, of really trying to work on the front end to prevent that. And one last point I want to raise. I'm representing a client right now in post-conviction relief through a bill that was passed in Maryland, neighboring Maryland, to allow individuals who are under the age of 18 to have their sentences reviewed after 20 years. And he's in prison in Hagerstown. And a few months ago, when I was visiting him, we were just sort of talking just more generally about, the people in prison. And he said something that was just so striking to me, which was that, there's a lot of broken souls walking around here. Right. And his broader point was just that so many of the people who we incarcerate, right, are people who've been there, especially our children. They're there because we ran out of options because the trauma that they experienced, we didn't address on the front end. I also served as a guardian ad litem in DC. And I remember there was a case where there was like a 4-year-old boy who the case came to us because his father had been killed by his uncle. And he watched this happen, right? And thankfully, we were able to get him into counseling, court order counseling with his mother. But so many kids who have those similar traumatic experiences don't get access to that. And so I think, the point that you all are raising is one that's really important, which is reinvestment in communities that are impacted by violence, making sure that when we do know and we can screen for ACEs and childhood trauma in our schools and communities, that we actually invest the resources so that kids can get counseling, so that kids can, get the services that they need, so that those traumas don't become problems later on and that those same kids end up in the justice system. And so just really appreciate all of the different points everyone's raised. And that leads us really into this conversation around ACEs and trauma and, what role does that play in the context of, a kid who, has ended up in the system. And we know that they have this tremendous trauma history and background. Doug at the beginning talked about Centoya Brown being a child sex trafficking victim who killed a man who she thought was going to harm her. We have so many kids who end up in the system in similar circumstances or have been victims of crime, right? And so the question that I have for you all is, how much of a factor should prior childhood trauma play when prosecutors and courts are deciding how to hold children accountable for crimes that they commit? And how does your office balance these considerations with the need to protect public safety, which is a very delicate and difficult balancing act sometimes when we're talking about, what's in the best interest of society and what's in the best interest of this child? How do we protect their human rights? How do we recognize childhood? And how do we recognize that trauma that they've gone through? So I'm going to throw that out there to anybody who wants to, solve our Commonwealth's problems right now.
I'll start because I have just a quick response, and then I'll turn it over to my 3 colleagues. So a couple of years ago, someone started talking about ACEs and how important they were and how it mattered and all this. And I was like, what's an ACE? I just didn't know and was totally uneducated and naive and ignorant. And when it was explained to me and how vital and important it was in the science, our whole entire office went through a training and a presentation on ACEs, and we learned all about it. And so we became conversant in something that we weren't otherwise conversant in. So my only point is a starting spot for me and for our office was to go listen and educate ourselves on it so that we could understand it and present it to judges and have conversations with defense attorneys. I think it's vitally important. Ramin, at some point tonight, was talking about the science and what does the science show. And I think that as prosecutors, we need to sort of humble ourselves. We don't know everything. We don't understand everything. We've got to open ourselves up to different things and educate ourselves and train ourselves. And so that was my big thing, is like, wow, how I just have no idea what's going on. And so we all sat through a really great training and learned about it. So it's vitally important to us as Charlottesville prosecutors to understand it and incorporate it into our decisions as we, shepherd cases through the juvenile system.
Would anyone else like to pick up on that and share some thoughts?
Ramin, did you want to say something first?
Oh, I always have something to say. I'm just trying to give everybody else a turn. But yes, I can talk briefly about this. One of the more controversial juvenile cases that moved through Norfolk in the last couple of years was the case of a 14-year-old boy. He was essentially serving as the caregiver for his 4-year-old half-brother. And his method of dealing with his little brother being 4 years old was to beat him and beat him and beat him. And eventually he beat his 4-year-old brother to death. His brother died of an aortic shear, bled internally. And his mother and effectively stepfather, boyfriend of the mother, when the child started to cough up and defecate blood, was not to call 911 until it was too late. And so the mother and father are both doing 21 years and 18 years apiece for just absolute depraved indifference to the life of this little 4-year-old boy. And my predecessor made the decision to send this 14-year-old to adult court for murder. And what do you do with a 14-year-old boy who beats a 4-year-old boy to death? And what do you do? Now, it came to light that the reason that he beat his little brother like that was because that was all he had ever seen. It was all he knew of discipline. It was all the discipline that he had ever experienced. And you don't leave a 14-year-old boy to take care of a 4-year-old. You just don't. You don't. And fortunately, our judges understood that and imposed appropriate sentences on the adults who both created a 14-year-old capable of killing a 4-year-old and left that 14-year-old in charge of the 4-year-old. And, I really had to struggle with what to do with this boy. He's a boy. He just turned 18. He just turned 18. Then, he was in adult court, and I don't know that I would have second-guessed that decision. That's a tough one. But during his time in juvenile detention, he was perfect. He was absolutely perfect. He didn't act out. He took his classes. When it came time for his sentencing, he had character letters from the caseworkers in the detention home talking about how he was the best kid that they had worked with, whom they had worked with. And there were no good answers. And because we were dealing with a damaged child. And we were also dealing with the fact that this child was ultimately, set in motion the death of his little brother. So the decision that I ultimately made, and it was my decision, I own these big ones. I don't, I consult, but they're mine, because the voters voted me in, and if they don't like it, they should vote me out. And my decision was for a definite commitment to the Department of Juvenile Justice until he was 21 years old. Not an indefinite commitment, not a serious offender commitment, because frankly, I thought he might get out earlier. And his plea was to manslaughter, it was not to murder. And with an entirely suspended sentence thereafter. And I got heat. I got questions from the press. I got questions from other people. Why are you doing this? He killed somebody. And I said, because he was a kid. And because this kid, was turned into the 14-year-old who could kill a 4-year-old boy. And, we're going to give him until the age of 21, where his brain is mostly online. And we're going to hold him, and then we will release him, and we will hope that the rehabilitative solutions in the Department of Juvenile Justice will give him the tools he needs to thrive. And that we don't put him in an adult facility, possibly to unlearn those lessons. And that, frankly, if he goes out and kills again, that we have a 10-year sentence that I will impose on him without reservation. Because at that point, he'll be an adult. But his childhood trauma absolutely controlled that decision. I don't believe in the myth of the super predator, but if he came from a life of privilege, with no trauma, all the advantages, and he beat a 4-year-old to death, his experience, his explanation for that, 14 or 24, would be different. And, I know that Joe and Allison and Shannon have made these sorts of decisions, but, as I've said in other contexts, a lot of the decisions we make as prosecutors are between bad and bad. And this was a situation where I felt that treating this child as a child was important under the circumstances because of his adverse childhood experiences, even though what they resulted in was one of the most horrific crimes that you could possibly imagine. And I trust one way or another, I promised my voters that I would always do what I thought was the right thing. If they don't like it, they can kick me out. But I felt that was the right thing under the circumstances to do. And that's the kind of decisions we all make as prosecutors. We all do our best.
I'll just kind of wrap this up from a different perspective, because I see that Emily Virgin has asked a question about, like, how do we educate prosecutors, who may not see things the same way that we are discussing this evening, from groups who are very passionate about kids. There's also the saying of, you don't know what you don't know. And when you're asking these questions about why did this young person, this kid, do this horrible thing, and you as a prosecutor have no basis, if they've never had any, I use the term, meaningful, if they've never had any prior contacts with the juvenile system, or what contacts they have been through, either some type of custody issue, or maybe some other type of civil, maybe it's a chins, maybe you can glean something from that file. But when the law starts off from a premise that we don't get to ask for these types of examinations, this is what we have to rely on the attorney representing the young person to want to know certain things, to ask for certain evaluations, and then further be willing to share that information. Because what I do hope, and I think that we do this well here, and I'm going to assume, because I know my colleagues here, that this is definitely true elsewhere. Whereas when you're dealing with juvenile cases, everybody does want to get it right. And it's either getting the information, the appropriate mental health, background, so that the defense attorney can advocate for the mitigation. Now, sometimes it may not present what they expect. And we may have, a diagnosis out there that actually might be kind of scary. And then, to Ramin's point, like you're stuck between a terrible decision and a terrible decision. But at the same time, you're just trying to figure out, like, how did we get here? And I think that's where, to make sure that we have, colleagues on the other side of the aisle who are willing to, advocate zealously for their client and what they are ethically bound to do, but understand that, again, we're talking about a child and rehabilitation, that they would hopefully want to know that information. And if it is something that is useful, to share that information with us so we can figure out the best response. But again, you don't know what you don't know. And then just lastly, it kind of falls back again to that argument about the resources that are there. If I'm in Henrico County and my VJCCCA has programs because my county is well off to, to bolster that, state amount of money, that's great. But I may have a colleague down in another part of this state who does not have the same type of resources I have, or don't have a, King's Hospital with their awesome child psychologists, which is fascinating and awesome. So then what do we do? And how are we also trying to make sure that kids across the state are getting the appropriate responses, and it shouldn't matter what their zip code is?
Thank you so much for that, Shannon, Ramin, and Joe, all of you. Thank you for your responses to these questions. And I want to lift up that Kelly Carlisle at VCU Health, she has offered to do trainings for any Commonwealth Attorney's office that is interested. And Kelly, I just want your permission to share your information in the chat. So all Commonwealth attorneys and folks who want to help other Commonwealth attorneys come along, right? Because sometimes it's like you said, Joe, you don't know what you don't know. And if you receive this training, then how much more compassionate might you be? And so, Kelly, I just want to share your contact information if that's okay with you. Perfect. Thank you for dropping it there. She has dropped it in the Q&A. So, and then I'm just going to go ahead and put it in the chat as well. And I also want to just lift up quickly that VCU is one of our partners, along with it's Rise for Youth, Human Rights for Kids, and VCU. We are working together on this Redefine the Vital Sign campaign, because we really do need to begin taking a public health approach to public safety. If we want safe communities, we're going to stop using every free dollar to increase police presence, and we're going to start using some of that money to increase all of the supports and resources that are going to address the mental health, that are going to address the adverse childhood experiences, that are going to address the sheer lack that some communities are facing. You know, I mean, when we look at the top category of offenses for children being locked up in DJJ's custody, it's the stealing crimes. It's robbery, larceny, and burglary. That tells us something, right? And then second to that are the violence, all of the different violences that you can commit against persons. If that's what kids are doing, if they're stealing things and they're hurting each other, we've already heard that hurt people hurt people. We already know that when you live in lack, that you're going to try to figure out how to get your needs met and even some of your wants met. And you're going to find your own means when traditional means are not made available to you. And so we've got to now start taking the approach that we're going to begin to address those issues. And it's a public health approach, rather than, we can't drop it in the lap of our prosecutors to say, okay, here are all these issues, can y'all fix them? I know they have come all the way through all of these other systems, and now here they are at your door. Now we need you to, what? Let's stop. There is no magic bullet. It requires all parties to come and be a part. This is a very needed conversation. And I don't know that we actually have time for more questions, because we want to give each and every one of you the opportunity to share your closing remarks. And we don't want folks having to kind of try to squeeze in that last thought. But I just wanted to share that it is imperative that we start looking at the needs of every community, not just the criminal justice perspective, right? We've got to look at what the school system is looking like, what the home lives are looking like, what the resources and resource development plans for communities look like, and ensure that police budgets do not double, triple, and quadruple in amounts to all of those other needed resources that ought to be invested in communities that are hurting. With that, James, I'm going to turn it over to you to kind of give your thoughts, and then I'll allow you to then just kind of collect those final thoughts from our panelists and close us out.
Yeah, absolutely. Well, Valerie, thank you. And thank you to Rise for Youth and VCU and, all of the support that we've gotten to do some of the really great organizing work and policy advocacy in Virginia. It's just been really great. Also just want to shout out the Weisberg Foundation that's supporting the work that we're doing together as well. And, I think for me, the big thing always comes back to, what are we doing for children? What are we doing to make the system better? And one thing that I would love for, our Commonwealth attorneys, if you don't mind, and if you guys are okay with this, maybe as you were reflecting on sort of your final thoughts, the last sort of question or idea that we would throw out to you is on the prosecutor guidance that we shared, right? And I will say it's sort of we sort of occupy sort of this funny space in the criminal justice reform space, because we're having this really great conversation with prosecutors, and we have prosecutors on our board. But I will tell you, when I go back and I talk with public defenders, sometimes it's a very complicated conversation, right? Especially when we start talking about blended sentencing. And I think, public defenders in Virginia have a very different view of the blended sentencing statutes than, for example, colleagues that I work with in the public defender's offices in like Maryland or other places, right? I happen to be a big fan of the serious offender review statute that you all have, because I think that it actually is a workable solution to a very complex and difficult issue, which is, what do you do with very deep end kids who commit very serious crimes like sex offenses or murder, or these very serious crimes. Now, I will say there are treatment programs out there, like the Mendota Treatment Center in Madison, Wisconsin. It's run by a guy named Greg Van Rybroek, that has been in operation since 1992. They only see deep end kids, and they have a 0% recidivism rate for violent offenses for every child who's gone through their program. It's intensive cognitive behavioral therapy, individual treatment, group therapy, all of those things. And so there are models out there for what we can do with deep end youth. But I also think that the serious youthful offender statute is an example of that as well, where Ramin, like you gave the example with the 14-year-old boy, where we can give that child every opportunity, right, to stay in juvenile court, this juvenile system, get treatment services, review their progress. And that's, and I bring that up and I focus on that because that is one of the things that we're trying to encourage with this guidance. It's one of the things that we want other state legislatures around the country to also adopt, so that if you are seeking to transfer or seeking to certify as an adult a juvenile, that there's always that serious offender designation, so that we're giving that child every single opportunity to show that they can change, that they can be rehabilitated. And we also recognize, right, that that's not always going to be the case, that public safety may dictate that some individuals have to be incarcerated for longer periods of time, right? And we're not blind to that reality, but we're also trying to incorporate this broader human rights frame that says we need to treat children differently. And so as you all are wrapping up with your remarks, one of the things I would like your thoughts on is the prosecutor guidance that we shared with you all. If you would be willing to commit your office to signing on to the principles that are outlined in it, or some variation thereof, right? So we won't sort of pigeonhole you and require you to say, yes, we're gonna follow this guidance exactly, but some variation where with those three big questions, when you're seeking to certify a child, when you're seeking determining what venue to charge that child in, and what sentence ultimately to recommend to the court if a child is tried as an adult, will you abide by those broader principles and that guidance that we've highlighted? And so I will go ahead and Joe, you're the last person on my screen, so I will start with you to give your closing remarks and give some remarks on the prosecutor guidance, and if you're willing to sign on to those as principles for your office.
Yeah, first of all, just thanks for such a great conversation. I really learned so much, and I always enjoy appearing with Shannon and Ramin and Allison. It was nice to meet you. But so I hope everyone heard Valerie's passion when she was addressing us. And I think that this sort of work and children that are involved in the system, I think that passion that Valerie showed when she was just sort of addressing us is really vital. I think you can't go into this sort of apathetic. That I just really appreciated that energy and passion, Valerie, and that sort of inspired me. I've quoted a judge, I'm going to quote another one. He said, whenever you make a rule, the exception walks through the door. So I would say this, I'm in a little bit of a kind of an unfair position. I sort of anecdotally went through the last 30 years in Charlottesville. My predecessor, Dave Chapman, was the elected for 24 years, and I've been in for about 6. I think we've certified 2 kids into adult court in 30 years. One was a 17-year-old that had been involved in 5 different shootings. And then another he was younger, but it was a really super violent attempted rape. So, James, I would love to continue the conversation. I love the 3 principles and the guidance and have no problem with it, and would love to kind of further the conversation about what that looks like formalizing it. But it's great work, and I'll my closing is, treating kids like kids. And when the public defenders, sort of push back or don't get what they want, did we listen? I I really like listening to Ramin. These are hard decisions we have to make. And if we do it with humility and we listen and we consider everything, at the end of the day, people might not be happy and we might not agree with what they're asking us to do, but did we listen? And I think we need to be able to say that in each and every case is we listened, we considered everything, we gave a decision, we justified it with transparency and sort of said, here's the best we could do. And I also love what Ramin said. It's, we're choosing between bad and bad sometimes, but we need to continue these conversations. And I'll end with one little plug for Shannon. We are so lucky to have Shannon leading VACA. And, and I heard her remarks when the gavel was passed to her at the executive conference. And Shannon does not want to represent people that agree with the people on this call. She wants to represent her 119 colleagues from all over the Commonwealth. And so we're going to be really well served by her leadership. But great conversation. Thanks. Look forward to continuing it.
Thank you, Joe. And then Ramin, you're next on my screen.
Sure. If we're talking about general principles, like I agree. And that's what I've been doing. These are the things that we all, I think, as progressive prosecutors believe. Now, Joe is correct, and you're correct, James, in talking about it. There are always exceptions. My 14-year-old kid, he was the rare exception where the serious offender commitment for one reason or another was not what I thought was appropriate. But it is something that generally works better than sending a kid to adult prison. So as long as we're not talking about categoricals, because you can't, there's always going to be an exception. These are generally what I think what my office and what Shannon's and Joe's and Colette's offices are doing. And one thing I'll say is that I do see some hope that we are progressive prosecutors at this point represent about 20% of the national population. But in terms of absolute numbers of electeds, we're still pretty small because we tend to represent big places. But I can tell you that 2 years ago, when there was a debate over raising the age at which children could be sent to adult court, even a very traditional organization like the Virginia Association of Commonwealth Attorneys, everybody kind of looked around the table and said, we can support that. Their mindsets had evolved. People recognized that they didn't have to do it that way anymore. So, the putting this information out is not just for us, who are the converted who are sitting in the pews, it's also for the folks who are trying to evangelize to. And I think that when it comes to the world of juvenile justice, there is more of an appetite for recognizing the need to treat kids like kids now than there was 10 years ago. And there's more of an appetite for it than there is in recognizing the need for greater proportionality and greater reason, frankly, in the adult sphere. So that's the next frontier, is talking to people about how experiences of trauma and the like inform the crimes that adults commit.
Thank you, Ramin. And then Allison, you're next.
I just want to say thank you for allowing me to be part of this conversation, especially with my much more esteemed colleagues and having a part in this conversation. I feel lucky to practice in a jurisdiction under Colette where we've employed many of these things already with our written policy. Our office policy puts into place many of these and even I think surpasses many of these. So we will continue to use that policy and employ that policy and make sure that is what is happening in our office.
Great, thank you. And then it's certainly not least,
As we say it again, last but not least.
Madam President, if I may.
Well, yeah, I don't know how profound this last statement will be because I certainly appreciate what Joe has said and what Ramin has said and our dear friend Colette, who obviously we're thinking about her during her personal time right now, is that for the electeds here, we're the ones on this call who are doing these things already. And what I liked what you were saying, James, is that I'll be honest with you, I didn't think there was anything other than doing a review at 21 years of age. I'm like, how could you not review this child as they've gone through DJJ, and then doing the assessment before they go to DOC, if that in fact is even necessary anymore? Like, I can't even conceptualize that. So, but I will say that, I like this idea of even doing of additional reviews, because again, my kid who is that, round peg trying to go into that, triangle hole may need that additional, look. And, I know Ramin talked about, the second look legislation, but this is something that would even just be like a second and third, maybe every 5 years there's a child with a particular diagnosis that really does need that additional kind of guidance and review as they're going forward. And unfortunately, the way that our systems are set up, DOC doesn't have that, right? And I do implore that the actions of these community groups like, Human Rights for Kids and Rise for Youth, and having all of the committed groups, communities, the leaders at the same table to talk about what we know, what works in other states, what changes we have looked at before or maybe haven't taken a look at before, but that really do make a positive impact on our young people who are going to, as we always say, coming back to us, and we want to make sure that we're giving them the necessary, equipment to make sure that they're healthy when they come back to us. That's what we need to do. We need to focus on this multidisciplinary approach, like Valerie said, and I have said these 10,000 times. There are certain aspects that we've been addressing public safety wise that have to be public health wise, and whether it be autism and understanding what has been happening with the diagnoses, like Ramin said, the defiance, syndrome. One category of kids are getting this one label, but another category of kids have been looked at this way through the public health system. Understanding historically what has been happening, understanding that there are good changes that we can make presently, that we can make positive, movement going forward. That's what I really hope that we will all gather, glean from this conversation, and understand that the participants who are here today, I'm sure a lot of them, I can tell by their questions, they're also very active, and we can come up with some great ideas moving forward and make the significant change to make the Commonwealth of Virginia an actual leader in this nation and set a great example for everyone of how we're dealing with our youth.
I'm so appreciative for what everyone has shared this evening. And James, I know I said that I was going to let you bring it home, and I am going to pass it back to you, but I want to invite everyone, please go to check out Human Rights for Kids website. There are so many valuable resources there. Go to Rise for Youth's website. And there is a survey on our website right now, and it is attached to our Redefine the Vital sign or hashtag RTVS page. Take that survey. I know that you all here, our panelists, you will know the answers. You are going to get a 100 on the exam, if you will. But, I would still encourage you to take that survey. And then, because some of those questions, they aren't, it's not testing your knowledge, but asking for your opinions. And so we want our work to be informed by all stakeholders. And so please take the time to go and take those surveys. I hope that everyone who has tuned in this evening, you've learned something. You are willing now to go the extra mile and do a little bit more, that you're going to be that advocate, that you'll come to the General Assembly or tune in and testify. You'll send a letter. You will, I really enjoy hearing Mothers Against Drunk Drivers. If they were sitting in a courtroom and things weren't happening how they wanted, they were talking to legislators to say, hey, this particular judge is not operating in the way that is most conducive to justice in our jurisdiction. That's a real thing. I hope that everyone has learned something on this call that is going to light that fire under you. I know I happen to be that passionate one. I just am. But you know what? That's what it takes, right? We've got to mean it with every fiber of our being. We've got to be willing to pour all that we have into it. That's how we're going to get a Commonwealth that is just, for all. That's how our young folks are going to grow up and thrive. That's how we together are going to be able to see the end of structural and other isms, right? We have several isms to get rid of. Racism is a huge one, but there are others. And so together we can, right? Together we can, together we will. And so I just encourage every one of you to ingest this again. Don't let this be the only time you engage. This was recorded. So you're going to be able to find it on Rise's site and on Human Rights for Kids and also on YouTube. So go back and get some of those nuggets, share them with others in your networks. And together again, let's make Virginia better. Thank y'all. And good night. Thank you to each one of you panelists. Thank you so much for sharing all that you are and all of your expertise. Thank you. And for how you are doing the work that you're doing in your offices. Shannon, I'm excited. I'm hoping that you took down Kelly's information and perhaps, there can be a training for all prosecutors, right?
Absolutely.
Yes, yes. I'm excited about all the good things that are going to come from this. Y'all have a good night.